Thanks for staying with us. A Bloemfontein Court is in session to hear the bail application of former Free State Head of Department of Agriculture, Peter Thabethe, and businessman Iqbal Sharma, an alleged Gupta associate. Let's take you there live.
Thank you, Worship. Your Worship, as again on Thursday I make the same submissions, that one should get back to the basics of these proceedings. And therefore, I start off with Section 64 of the Criminal Procedure Act, which deals with whether there's a likelihood in one of the subsections A to E on the evidence now before you. And if there is, then there's an onus, obviously, on the applicant why the interest of justice should determine whether he be incarcerated or not. But this again goes a little bit further than that. It's not a Schedule 1 but a Schedule 5 offence. And therefore there's an extra onus on the applicant in terms of Section 6011, subsection B, to convince this Honourable Court that the interests of justice do not determine his further incarceration on the evidence before you. That's the core of this application. Now, Your Worship, also, it's important to understand that it's not only the Criminal Procedure Act but also the National Constitution that plays a role here. In Section 39 of the National Constitution determines the interpretation of Bill of Rights. And those values underline an open and democratic society based on human dignity, equality and freedom. And therefore it should be determined and promote the spirit, the purpose and the objects of the Bill of Rights in subsection 32(9) of the National Constitution, as read with Section 60 here. And Your Worship, I have listened carefully on Thursday and also today to the opposing affidavit. I'll get now to whether the applicant has convinced you, but let me just first deal with it backwards. If I look and evaluate the affidavit, Your Worship, my submissions are simple. There's no likelihood in that affidavit as set out in subsection 64D, and I'll submit to you now why. Because if you look at my learned colleagues' submissions to you, I refer you to subsection 68, which deals more further with subsection D, which is actually the ground on which they oppose the bail. And if you look at those subsections in subsection 8, there's nothing that assists them except they refer you to the last one, any other factor the court might take into consideration. So it's hanging in the air. Which one? What do they want? Another factor for yourself to take into consideration. And if I read the gist correctly, I understand they are saying, yes, because there was previously an Estina charge which was withdrawn previously against the applicant, and yes, because there's another charge that is standing trial in the High Court in November for the month to the tune of 225 million. There is this tendency that is committing these things and therefore jeopardizing the criminal justice system. That's completely wrong. They are putting the cart before the horse. What's happening here? These allegations in this application is oldest, 2011. So it can't put a reverse onus to say they're consistently committing crime or have the tendency to jeopardize the criminal justice system. If it had been after the other matters that they have got bail, I would understand. So the argument, with all due respect to my colleagues, are completely wrong in terms of these applications. And I submit there's nothing before you from their side to oppose. They should never have opposed this bail application. There's rather an onus on the applicant to convince, and I deal with that now. Your Worship, if you look at the evidence placed before you by the applicant in his affidavit, it's undisputed, firstly. He is a retired individual who was a senior person in the department in government. He works farms, he has people who are dependent on him, families, income. And clearly, if there's no likelihood in terms of any of the other prerequisites, the interest of justice does not dictate, as the national constitutions are to infringe his free pending allegations in a charge sheet that has not been proved. He says under oath in that affidavit that I don't have a strong case against him. That's one of also the prerequisites which you will take into consideration. But I think most important is the time frame of this hearing. It's very clear that he's mentioned in his affidavit months, but it's clear to me, Your Worship, with all due respect, if I listen to the opposing affidavit, it's going to take years. Can you imagine the amount of documents in these trials we all know so well? To incarcerate people who have roots in the Free State and married for 30 years and people dependent on them and all the personal circumstances would be a gross injustice not to grant bail. Interests of justice do not prevail to do that. So, Your Worship, I submit to you humbly that in terms of section 6011, subsection B, and also with regards to subsection 69, where the personal circumstances overwhelm completely the position of the state. In fact, there's actually nothing before you accept the applicant's version, and I therefore submit humbly that in terms of the case law, the Constitution, and really other many case law, which I will submit if necessary in reply if it becomes applicable, that Your Worship grant the application bail. He has discharged the onus upon him, and I respectfully submit all these allegations by the state are in the air. It doesn't supplement subsection 64D as they intend to do. This court pleases. Thank you, Worship.
Thank you, Mr. Colley.
As the court pleases, Your Worship, it's the state's submission that the accused did not, he has not, the onus that was placed upon him, he has not succeeded in this regard. The onus is that of the applicant, Your Worship. And I would further submit that with regards to the reasons for the state opposing bail, that the state had ample reason to oppose bail, as set out in the affidavit of Colonel Mutolo. The legislature would not have placed section 60, subsection 4, subsection D, into the act if it was not necessary. And the state has dealt with the reasons why the state believes that the applicant should not be granted bail. With regards to the offences that was mentioned, the affidavit does state that the 3 offences that implicate the applicant was committed in a very short period of roughly 3.5 years, from October 2011 to April 2014. And that paints a picture. And we cannot disregard the people of the Free State Province. We cannot say that the people of the Free State Province does not have any interest in this matter. And with regards to the strength of the state's case, Your Worship, the state will submit that the affidavit is before Your Worship, the indictment is before Your Worship. It sets out exactly how the applicant is implicated in the matter. So this is confident of a strong case in this matter. So the averment by the applicant that the state has a weak case must be, we oppose that averment, Your Worship, because we cannot agree with that. Having said all of the above, Your Worship, the state contends that it is not in the interest of justice to release the applicant on bail. As it pleases the court.
I just short in reply, just mention in reply to her submissions to you, Your Worship. Your Worship, please take you to the Criminal Procedure Act, subsection 60, subsection 8. Don't you read it to Your Worship? In considering whether the ground in subsection 4, subsection D has been established, the court may, where applicable, take into account the following factors, namely, subsection A, the fact that the accused, knowing it to be false, supplied false information at the time of his arrest or during the bail proceedings. That's not the fact here. B, whether the accused is in custody or on another charge, or whether the accused is on parole. That's not applicable here. Sorry, it's disturbing the mics. Anyway. Subsection C, any previous failure on the part of the accused to comply with the bail conditions on any indication that he or she will not comply with any bail conditions. Those three, and or then any other factor the court might take. So any other factor would obviously refer to those three. So I hear my learned colleague is making noises, not agreeing with me, but surely any factor doesn't mean any factor. It's obviously with regard to that subsection, because other subsections refer the same. My submission to you is, Your Worship, there's nothing in the submission that because this matters before you now, it is an indication that the criminal justice system is impeded. Because on the matter that they are on bail is after this. Well, that cannot be reversed, and that's where, with due respect to my colleagues, they are completely wrong. Your Worship, I submit to you that it's overwhelming in the case of the applicant, we grant him that he has, with due submission, discharged the onus upon him as the court Mrs.
Thank you.
The state has nothing further, Your Worship, except to say that we are only relying on the subsection D of subsection 64, 16, subsection 4, subsection D.
Mr. Thabethe, you may remain seated for now. I'm going to proceed with the judgment. Mr. Thabethe is an applicant applying for bail. The provisions of Section 6011B of the Criminal Procedure Act is applicable as he is charged with an offence as agreed by the state and the defence, which falls under Schedule 5. The duty is on the applicant to satisfy the court that there are circumstances in the interest of justice why the court should grant bail to him. The allegations that he is facing is several charges of fraud and money laundering to the amount of several million rand. He applied for bail in the form of a sworn statement, an affidavit. Briefly, without going into the whole affidavit, he indicated that he is married, he has 2 children, in university at the moment, his wife is employed, he owns farms, several farms and residences and a flat in Bloemfontein where his wife lives. He also owns a number of vehicles and other movable property. This includes his furniture. His assets is valued at several million rand. He has a pending matter which is currently pending in the High Court. He is out on bail for that matter. He intends to plead not guilty during this trial. He also has a number of people dependent on him as the employer, and he also has family members that's dependent on him. He indicated that he can pay bail in the sum of 500 rand. The state opposed 5,000 rand. The state opposed bail presented evidence in the form of an affidavit by the investigating officer. The state relied on section 64, subsection D, as the main ground why they are opposed to bail. Now, according to section 64D, the interests of justice do not permit the release from detention of an accused where one or more of the following grounds are established. And I'm just going to concentrate on subsection D, which the state relies on. The likelihood that his release on bail will undermine the proper functioning of the criminal justice system, including the bail system. The state indicated that the applicant committed the offences while he was employed in a position of trust at the Department of Rural Development in the Free State, and that there is a strong case against the applicant. The department lost R24,984,240, which was meant for poverty alleviation in the province. It's a serious offence. It's also a prevalent offence in the Bloemfontein or even in the Free State division. The investigation is complete. Witnesses are willing to testify. I also indicated that he has a pending matter of a similar nature, according to them showing a propensity of committing such offences on his part. It is also submitted by the state that if the applicant is released on bail, while he is already out on bail in a 244 million case, that there is a likelihood that it will undermine and jeopardise the proper functioning of the criminal justice system, as it will erode the public confidence in the criminal justice system. Because it may create the perception that justice favours the privileged, and the state requested the court to refuse bail. Now, in deciding on whether I should grant bail or not, I take into account the personal circumstances of the applicant and the reasons why the state is opposed to bail. The most important factors that I take into account are the fact that the investigation is complete, witnesses are willing to testify and available, the accused was previously charged for this matter and was provisionally withdrawn. There is no evidence that he attempted to interfere with the investigation or influencing witnesses. No indication that he attempted to evade his pending arrest for this matter. Although he has a pending matter of a similar nature for which he is out on bail, these charges before me that he's now facing emanated from incidents before the pending matter. The principles bail applications remains exactly the same, and the courts do not discriminate between the rich and the poor. All the grounds raised by the state in order to oppose bail are based on public perception. The courts may not allow public perception to rule its decisions. One must remember that bail is not a punishment. The situation would have been different if the applicant was out on bail on a similar matter and he committed these offences while he was out on bail. I therefore find that it is in the interest of justice to grant bail to the applicants.
As the court pleases you wish.
Can we just agree on amount of bail which is suitable? I know that the defence indicated 5,000 rand.
Can I take an instruction
I think
quickly?
that is a little bit too low.
Can I turn my back on you?
Yes, you may.
Thank you, Worship. I'm indebted to you. Your Worship, he is in a position to pay the same as the others. I think my learned colleague has agreed to 10,000. With regards to his passport, Your Worship, that is in Mpumalanga. If we can just arrange with Lieutenant Colonel Motolo that he liaises with the accused to hand it in where it's suitable within, let's say, as close as within the next few days, as you deem fit, and then hand it to him. With the rest, it's the same normal conditions as previously, if the court pleases you.
Okay, when will the passports be handed over?
Can I ask them to tell us, then we'll abide, Your Worship.
Sorry. We will communicate with the defence, Your Worship, with regards to the passport. Because we still have applicant number 4's matter to deal with, so we don't know. Yeah, let's say within the next 7 days, Your Worship.
Thank you, Mr. Thabethe. You may stand. Your matter is then, your bail is granted in the sum of 10,000 rand. Bail conditions are that you must appear in court on every postponement date, 8:30 in the morning, that you stay present until your name is called, and that is at the court to which the matter is postponed to. You must also please hand over your passport, that's one of the bail conditions, to the investigating officer on or before the 14th of June 2021. Failing to comply with the bail conditions will result in a warrant of arrest being issued for you. Your bail will be provisionally forfeited to the state, and upon final forfeiture of your bail, you will be kept in custody until this case is finalized. Do you understand your bail conditions? Thank you, sir. Your matter is then also now postponed as the other one, which was the date, the 7th?
5 July, Your Worship.
5 July 2021. It's a provisional date, and you won't be back at this court at 8:30 once you've paid your bail. Thank you, sir. You may stand down.
If the court pleases, Your Worship, I'm not sure whether you're going to adjourn now, or can we be excused if you're not going to adjourn?
I don't have any other matters to deal with except the other bail application, which...
I don't think they're ready. Maybe you'll adjourn then, Your Worship.
Yeah, my request and adjournment.
Thank you. The court will then adjourn.
Court pleases, Your Worship. I'm invited to assist us, Your Worship.
All right, we're not so sure about Iqbal Sharma. We'll get details on that later on, but bail has been granted to Peter Thabethe for 10,000 rands. And of course, the judge there reading out the conditions of the bail, including that he must be present at every date that is set for this matter, but the matter now postponed to the 5th of July 2021, and that's a provisional date as well. Peter Thabethe granted bail of 10,000 rands. We'll bring you details in terms of Iqbal Sharma, what the outcomes were for him. Remember, we have that conversation with